Hello and welcome to the Blcbox. My name is Rory O'Neill and I'm joined in the box by Dr. Miroslaw Wroblewski. He is the Director of the Constitutional, International and European Law Team at the Office of the Polish Commissioner for Human Rights. He's a member of the Management Board of the European Network of National Human Rights Institutions. He was a member of the Management Board of the EU Fundamental Rights Agency and is the current Vice Chair of the Human Rights Committee at the Polish National Bar Association. Mirek, welcome to the BLC podcast today.
Yeah, hello, Rory. Good morning, everybody. Thank you very much for the invitation.
So among the many absolutely spectacular things that the Office of the Polish Commissioner for Human Rights does on a daily basis to protect, promote and educate on the fundamental rights of Polish individuals, the office is also at the vanguard of actions to protect the Polish judiciary from excessive political interference. This is the topic that we're going to be talking about today. Before we begin talking about this, Mirek, would you mind giving us a brief introduction for our international viewers about what exactly it is that the Polish Human Rights Commissioner's Office does?
The Commissioner for Human Rights is a main human rights institution in Poland responsible for the protection of all fundamental rights, including right to access to independent court. So the number of complaints is reaching 60,000 per year, and especially in the times of coronavirus, we actually reached the number for the whole year already. So it's especially busy year. And yes, it is additionally very busy because of the problems with the judiciary. We see this issue from the perspective of the access to independent court as a kind of a meta right, which practically guarantees the effective implementation of other fundamental rights. And at the end of the day, you may complain to a common court, to administrative court, and then you have to be sure that your case will be dealt with impartially. And therefore, the Commissioner pays a lot of attention to the construction and main guarantees of independent and impartial judiciary.
Okay, so then before we even get on to that particular topic about the right to an independent court, am I right in understanding then that individual citizens have a constitutional right to submit complaints to the Ombudsman's office? And once they do so, what does the office do with those complaints? Do you have the right to then go to court on behalf of those individuals to enforce their rights?
Yes, the Commissioner for Human Rights is an ombudsman institution. It's at the same time the National Human Rights Institutions and the Independent Equality Body, and even more functions are under this one head. It's also National Preventive Mechanism. But yes, indeed, any person can file a complaint to the Ombudsman for the protection of his or her human rights. And the Ombudsman, the Commissioner, has many possibilities to conduct an explanatory proceedings, to take proper actions like access to government files. So we can give recommendations. We can also initiate and participate in different kinds of judicial proceedings. To explain everything, it would need the other, I would say, meeting to say how active the Commissioner is. But just to give you an example, that currently we are involved in over 200 judicial proceedings of different kinds, ranging between penal proceedings at the level of the Supreme Court up to the insurance cases in the district courts. So there are a number of issues, of course, when it is not only about the, I would say, the case as itself, but some cases concern the, coming back to your first question, to the issues of independent judiciary. The Commissioner participates not only in proceedings before national courts, but this is a practice we have from the last 5 years, or we file amicus curiae opinion before the European Court of Human Rights. And being a part of national proceedings gives us also an opportunity to participate in proceedings before the Court of Justice of the European Union if the national court approaches the court in Luxembourg with preliminary reference.
So that brings us on to the question about this discussion about the independence of the Polish judiciary. So for any of our non-Polish viewers, I'm sure somebody has heard something in the last few years about the crisis of the Polish judiciary and the political interference in the structure of the Polish courts and over the independence of judges, and also the various actions that the European Commission has initiated before the European Court of Human Rights, the European Court of Justice, regarding that and whether that's an issue of EU law. So what's the current state of that issue? Because that's something that's been going on for a while. And what role does the Commissioner's Office have in that series of actions that are ongoing?
Of course, the Commissioner for Human Rights cannot force anybody to change its policy or legislation, but we may intervene in different judicial proceedings, as you reminded, and express our opinions and recommendations basing on the Constitution and international standards, but also on the important line of jurisprudence by the Court of Justice concerning rule of law. And this is a very important part of our work. The current state of affairs. Unfortunately, I'm coming back to the roots of those crises. Many problems with the excessive political control would be solved if Poland has a properly functioning constitutional court. This is something which is lacking. This was the start of the whole crisis, that the Constitutional Court was captured by the political interference. It has been lost also as a legal tool for the Commissioner. Beforehand, every year the Commissioner filed 20, 30 cases before the Constitutional Court to assess constitutionality and compatibility with international standards of parliamentary and government legislation. Many problems has been solved. of course, you may assess the judgments as very good, so maybe not sufficient, but nevertheless, it was the independent constitutional court. Now, there is no trust in the society, no trust between judiciary as regards the constitutional court. Therefore, the great majority of cases coming to the constitutional court come from the government, from the president or the prosecutor general, and the main function of the constitutional court is rubber stamping of legislation. It is like a certificate of legality and constitutionality, but it's not serving for the protection of human rights. So therefore, those cases concerning the political interference into judiciary, both at the level of common courts and the Supreme Court, and the very important body, National Judiciary Council, which main task is to select candidates for judges' position and then putting them for the nomination by the president. So all those problems could have been solved by the Constitutional Court. With the problems we have, they became an issue in the preliminary references procedures initiated by Polish courts or by infringement actions initiated by the European Commission. The main principle was and is the principle of effective legal protection enshrined in Article 19 of the treaty. So this jurisprudence actually allowed for the protection of independent Supreme Court. So those judges who were to be fired because of the lowering of retirement age have been saved. However, new chambers were created in the Supreme Court. One is the Chamber of Extraordinary Appeal and Public Affairs. The second is Disciplinary Chamber. There were many doubts concerning this disciplinary chamber because this is the final body responsible for the disciplinary sanctions against judges. Currently, it's only 8th of April, if I remember the date, that the Court of Justice has issued a temporary measure, an injunction to freeze, to suspend the whole chamber in all disciplinary proceedings. This judgment, so this temporary measure before the final judgment, is currently being implemented only partially by the Supreme Court and by the disciplinary chamber. Still, there are some doubts concerning the second chamber.
Can I just ask, can I interrupt you for 1 second?
Yeah.
Can I just ask which parts of the judgment imposing interim measures has been implemented and which parts have not?
This is, of course, a matter of interpretation of the injunction by the Luxembourg court. The Supreme Court and this disciplinary chamber decided to implement this injunction and to suspend all disciplinary proceedings against judges. But actually, the injunction is about the whole chamber, the functioning of the whole chamber. So there are other cases concerning disciplinary cases concerning other professionals, legal professionals like advocates, attorneys at law, or prosecutors. So, as regards these professions, the Supreme Court acts as before, and there is some kind of a peculiarity that disciplinary chamber is of an opinion that they can still adjudicate in other proceedings, like the proceedings regarding the immunity of the judges, which is a precondition for penal responsibility of judges. And actually, this was a case dealt with by the disciplinary chamber yesterday. Even if majority of opinion is about the obligation of the disciplinary chamber to refrain from deciding this case, the disciplinary chamber took luckily good decision, but this is quite a weird situation. That the commissioner's opinion is that they were not allowed to take this decision at all, because the whole chamber has been suspended by the Court of Justice. We know that the European Commission asked the government on the clarifications, how the Court of Justice ruling has been implemented. I think that it will be also dealt with by the Court of Justice in the final judgment in this case.
And if the Court of Justice doesn't end up saying that the government has violated, or well, there has been a breach of EU law because the disciplinary chamber has continued to operate, evidenced yesterday with the decision on immunity of Judge Igor Tuleya. What do you think the Court of Justice, what remedies are available, and what remedies can the Court of Justice deliver in its judgment on this issue?
Of course, each decision of the Court of Justice has to be implemented by member states. It is final. And it's legally binding. So infringement may cause another action by the European Commission, ending with pecuniary action. I mean, of course, with the fines and possible financial sanctions. So this is, I would say, a very dangerous game, that such misinterpretation of the Court of Justice decisions may lead to financial responsibility of Poland, and it will mean of all Polish citizens.
Okay, so that's a really good, I think, overview of the situation especially for our non-Polish viewers. But if I can just summarize, so like in your explanation, you've referred to three important constitutional institutions in Poland. We have the Constitutional Court, the National Council of the Judiciary, and the Supreme Court. At the beginning, you'd said that the Constitutional Court had been taken over already. It's been politicized, and the National Council of the Judiciary as well. And now we're at this stage of the Supreme Court, which is already subject to interim measures imposed by the European Court of Justice. Can I just ask that, because some people might not know that a few weeks ago there was an election in the Supreme Court for the first president of the Supreme Court. And if that came after the European Court of Justice had ordered the suspension of this disciplinary chamber, the judges who sit in that chamber, were they entitled, and do you think they should have been entitled to take part in the election of the first president of the Supreme Court as a rule of law issue?
This is, yes, indeed, they took part in the election process. They've been present during the assembly of Supreme Court judges, and they were involved in the decision-making process. This is a very dubious situation, because it is the whole injunction is about activities in adjudicating process, and it is there are legal doubts whether they were entitled to take part in these proceedings, and that's really an issue. But it will be only for the I would say finally for the Court of Justice to explain the final judgment what was the meaning also of the injunctions. The tricky situation is that actually what is very problematic is the whole law on the Supreme Court, which has been passed 2 years ago, and it has been changed in such a way that the Supreme Court is entitled to propose 5 candidates to the president. So the president, at the end of the day, has a very broad margin of appreciation and very broad margin of the decision. Theoretically, he could pick up the candidate with the least number of votes. And even without the presence of the judges, the people from the disciplinary chamber, he would, I would say, nominate the candidate he likes most. So one of the judges from the penal chamber who received 50 votes, so this is actually the majority of 90 and something judges taking part in the assembly, he was not nominated by the president, but the candidate with 25 votes has been nominated. But theoretically, he could nominate even the candidate with 10, who received 10 votes at the assembly. So, yeah, this is the situation. And Professor Manowska, who is the person chosen by the president, will run the Supreme Court, as for now, for next 6 years.
So is that would you say that that's an example of legislation that would have been reviewed on the grounds of constitutionality in the Constitutional Court had the court been functioning properly?
Yes, I'm sure that the Constitutional Court should review such a legislation very carefully. Without a normally functioning Constitutional Court, we live in the I would say the world full of constitutional doubts. We can express our opinions, but as long as these opinions are not taken into account by the legislator and public institutions, we have to still, I would say, accept or at least tolerate the state of facts.
Okay, so thank you very much for that. So I have one final question on this particular issue. So I know that we're in the middle of this problem, this dilemma. We don't yet know what the Court of Justice is going to say in its final judgment. We don't know what further action the European Commission is going to take. We don't know what role the EU Council is going to take if it involves itself politically in this dispute, and we don't know what will happen with regards to even the presidential elections in Poland that will be happening at the end of the month, and and all of that stuff which is still sort of in flux in a kaleidoscopic sense. But do you have any, maybe not even a prediction about how this story is going to end, but do you have an idea, or is there a roadmap of how to clarify these constitutional issues? What could be the solution to the problem?
Of course, this is a very difficult question. And let's concentrate, of course, on the legal aspects, because most of those problems could have been solved in a political way. Of course, it is always for the parliament to change legislation. Let's take it for granted. But let's assume that we have there is only this legal proceedings which can have any effect on the principle of independent judiciary. I am quite sure that the Court of Justice will follow its injunction and will say that the disciplinary proceedings against judges dealt with by the disciplinary chamber are not compliant with the treaties and with the charter, with the Article 47, the principle of independent court, and with the Article 2, the value of the rule of law, and with Article 19, the principle of effective legal protection. However, details will be very important because, as we discussed, those details are decisive actually for the whole functioning of the disciplinary chamber. And it is important to remember why it was already assessed negatively by the Court of Justice in the said injunction. The roots of the problem are the composition of the National Judiciary Council, which previously, and according to the Constitution, has to be comprehensive, and 15 members out of 25 have to be elected by the judges themselves, or at least with the great majority of judges. What has been changed is those judicial members are currently elected only by the ruling majority, directly by the parliament. This was something which was decisive for the Court of Justice, but also the practical operation of this chamber and practical operation of the National Judiciary Council has been assessed. The consequences, and I say about saying is whether it will remain at all in the legal system, and what will be the decisive factors of the decision of the Supreme Court. If the court will clearly and openly express or take a decision that in this construction the chamber cannot function at all, it would be crucial for the implementation process as regards this judgment. It would affect also the other chamber, the chamber of in extraordinary control and public affairs, which has a very important function. This is the function of confirming validity of parliamentary elections and elections of the president. So this is a crucial function in the democratic state. Without any election, any democratic election can be undermined, and the whole democratic state would be in a kind of a turmoil. So therefore, this actually decisions will be crucial. And I'm in my prediction is that Court of Justice will follow its injunction, but they would not dare to say how far it will go. We've seen many reactions currently as regards the procedural and institutional autonomy of member states. Of course, this is something totally different, but the decision of the Bundesverfassungsgericht, this ultra-vigorous judgment regarding the European Central Bank, is also a sign of a very tentative national courts. So this is a very delicate balance, and deciding on the Polish case, the Court of Justice has to have in mind the whole European Union, because it sets standards for the whole European Union, and it has to think also about the possible reactions of national constitutional courts and possible implementation of its judgments. So I would say finally, I'm not. I don't know whether to say being optimistic or skeptical, but being realistic. I have many doubts whether there is any possible roadmap narrowed to judicial proceedings only.
Wow, so you mentioned the judgment of the Bundesverfassungsgericht, so I kind of have to ask an additional question about that. But before I do, I have a different question. And that's to do with what we were talking about not being a roadmap. So the final thing that you said, and it made me think about the judgment, I think it was from last year or the year before, from the Court of Justice in Simpson and HG, where it talked about the appointment process of judges being a matter of EU law, and if there is undue political influence from the executive in the appointment process, then that could result in the denial of access to justice from an Article 19 or even Article 47 of the Charter as a human rights issue. So I'm wondering if the roadmap might be that this will come from the change, the proper protection and implementation of EU law might come from actions from your side, from the Ombudsman's office, because it might be that if we can show, or if we can argue in every single case that is decided by a judge that's been appointed by a politicized judicial council, or from a chamber in the Supreme Court which has been politicized as well, that every single one of those judgments can be challenged, and you'll be involved in all of those types of cases, that some of those cases at least will get to the European Court of Justice. And the Court of Justice, while having to give a judgment which is applicable for all of the courts of the EU, but mostly applicable to Polish judgments, because it will have to say at some point that judge satisfies the criteria for an improperly appointed judge, and the appointment process was a breach of EU law, and so the judgment that was given by that judge is a violation of EU law, giving that individual a different remedy, probably a financial remedy. So we would have all of these non-contractual claims against the Polish state in Polish courts, because hundreds and hundreds of judgments, and it will just increase the longer it goes on, will be delivered in breach of EU law. Is that something that you can imagine happening?
Of course, potentially there is such a risk, but we have to also take into account that there is another, I would say, stream of jurisprudence coming. This is the European Court of Human Rights. The Court of Human Rights has not still issued the judgment of the Grand Chamber in the Icelandic case, Astrason case, where actually the question is also about the political interference in the process of nomination of judges. But of course, the facts are totally different. But the Strasbourg Court has to assess how deep and how serious this interference was, and whether it affects Article 6 of the Convention, so the standard of the independent court. And this is quite a tricky problem because the other side of legal system, and also from the perspective of citizens' rights, we have the principle of stability of law and stability of courts' judgments. There would be a total nightmare if everybody would question the legitimacy of all kinds of judges and courts. So one cannot imagine, I would say, a more difficult situation. So it is also for the ECHR to decide to take transparent and clear-cut criteria from which point we may think of political interference, and below those thresholds are some kind of a minor mistakes which may happen in every nomination process, and they actually do not affect independence of a judge. Such clear-cut criteria are needed. But especially, I would say, in Polish cases, this is quite visible, that politicization of some bodies give a kind of a presumption of non-independence. So I hope that at least as regards the possible sanctions from the part of the political body, like the prosecution office, which is, I would say, there is a personal union in Poland between the same person being the Prosecutor General and Minister of Justice. So the political interference in disciplinary proceedings, which may be initiated by special disciplinary commissioners who are nominated directly by the politician, and also a possibility of the prosecution office to initiate penal proceedings concerning the judging process, the decision taken by judges in their work. If with the Court of Justice judgment, the biggest problems will be solved, and judges will be saved from the prosecution, from the political prosecution, even if theoretical. Because, of course, we have Judge Tuleya, and he's an example, but of course we have 10,000 judges, and so these are, I would say, not all are prosecuted. But even if this cheating effect is existing, it has to be eradicated, and the Court of Justice ruling can, I would say, sanate this difficult situation. Nevertheless, there is still the position of the Supreme Court, and with the two chambers, and with the first president of the Supreme Court, we have to think that the Supreme Court has the prevalent position as regards all other courts. They can overrule any decision taken. So even if the common courts are independent, they are secured, the political prosecution of judges is eradicated practically and theoretically. There is still a question of the functioning of the Supreme Court. I maybe even treated naive, and but I would like to believe that the first president, her first declaration was that she will keep the Supreme Court far away from politics. And I would like really to believe this declaration, but we have to follow it and monitor in practice.
Okay, thanks. So like that's my last question then on this topic. With regards to the May judgment of the German Constitutional Court, the Bundesverfassungsgericht. So as I understand it in that judgment, the German Constitutional Court asserted its ability to provide an alternative interpretation to EU law than the one that was given by the European Court of Justice. So it challenged or pushed up against the supremacy of EU law doctrine as it was adopted by the Court of Justice. Do you think that that judgment of the German Constitutional Court has benefited somehow the ability for political actors operating in the Polish judiciary to assert the independence of the national judicial reforms and the maintenance of national procedural autonomy and constitutional identity at the expense of the interpretations given to it by the European Court of Justice? Is that affected at all? Do you think it will have a benign influence, or do you think it has a negative influence, or how do you think that will be interpreted? Because we know that the president of the Constitutional Court of Poland did make a statement right after that judgment was given, saying that that is great, so the German court is following what the Polish Constitutional Court is saying as well, which was then rebuked by the German Constitutional Court president.
It's unfortunately, it's actually not the judgment as such. The German judgment is can have a potential negative effect, but I think that the wording, quite clear wording, stating that the Court of Justice judgment was given ultra vires, with such examples before many times. The Bundesverfassungsgericht was talking about the potential rebellion. The Czech Constitutional Court also declared the ultra vires judgment in the one of the social insurance cases. There's been statements by the Italian court and the Spanish Constitutional Court, and cases where those courts were of different opinion. So this is actually not a problem, because this is a kind of a judicial dialogue, even if given in harsh words. But at the end of the day, like there is still a room of maneuver and for this legal judicial dialogue. But when such judgments is used by politicians, it becomes much more dangerous. So I'm saying that this clear statement by the Bundesverfassungsgericht may be used by politicians and also by people unfortunately behaving politically, even in judicial positions. I hope not, but I must say that maybe it was not the best time to say such things, although it's totally understandable that it is not for the court to decide whether it will have any impact on the political stage of another member state, in another member state. But maybe it was a little bit unfortunate, saying objectively. So I think that we shall see what will happen next. President of the European Commission said quite, I would say, seriously about taking in action against Germany. So we shall see how it will be developed. But I think that there must be a clear declaration that it is not justifying for any member state to oppose Court of Justice rulings. And I think what the Court of Justice has to, I would say, do is also to follow its way. But maybe in its jurisprudence also maybe not take into account this political reality, but to take into account all those delicate issues. So sometimes it's also only about the wording, not about the merits of the decisions, but the proper words. It is very important.
So I just want to say thank you really very much for giving your unique perspective and experience on this particular topic. I know that's going to be really interesting for our Polish and also non-Polish students who are watching this. But I want to ask you...
Yes, I hope it's not interesting from the Chinese perspective. You mean the proverb, let you live in interesting times.
Yeah, that we should live in interesting times.
It's not this perspective.
No, absolutely. Well, we definitely live in interesting times. And another aspect of those interesting times I want to ask you about, and that's to do with the restrictions that have been imposed all across Europe as a result of the coronavirus pandemic. So, for example, in lots of EU countries, like in Ireland, in the UK, okay, not an EU country at the moment, but pretty much one foot in, one foot out. And in other countries, there have been a lot of court actions initiated by individuals who have questioned the legality of the restrictions on a constitutional basis. So I imagine that you are being overloaded as the body who deals with those issues from concerned citizens who wish to challenge the legality of the restrictions imposed by the government during the pandemic. Could you give us some information on that? Are you really busy?
Yes.
And so,
doing.
Oh no, there's a bit of a delay. Go ahead.
Unfortunately, I do not hear you now at all.
Yeah, I was asking. So, what's the position of the Commissioner's office with regards to the restrictions that were imposed on Polish society from a legal perspective? Is that something you can comment on at the moment, or is that an ongoing?
Because very briefly, because I could take hours to explain the changing situation, which has been very dynamic during last two months. It's like you can count 2 months into 4 years. We received more than 3,000 complaints regarding the issues concerning coronavirus legislation, let's call it like this, and especially all the restrictions enacted by the government on the basis of the law on fight with pandemic. Of course, this is a changing legislation because the government is ruling with the regulations issued by the Minister of Health or by the whole Council of Ministers, and it's changing every day. The main regulation is actually passed nearly every weekend. So this is also a very unstable legal situation. But the biggest problems were restrictions concerning right to move. And it's actually inflicted the main protests from the people. So all those restrictions concerning the freedom to move in public places, qualitative and quantitative restrictions, prohibition to enter the forest, enter parks and all other places, total lockdown, but also in the, I would say, defreezing stage, where government decided to, I would say, treat those restrictions more elastically and to open the state and leave down some of the restrictions enacted before. It was mainly about the, I would say, giving fire to economic activity, but taking care of any political freedoms, or even, so we may say that it was, there was more room was given to economic activity, to trade, than to freedom of religion, to participate in the religious gatherings or the political gatherings. So it was for the commissioner's office to speak aloud about those restrictions, which were, I would say, illogical, and they've been acted in with the violation of the constitution or with parliamentary legislation. As regards the judicial proceedings you asked for, actually, again, coming back to the Constitutional Court, with no trust to the Constitutional Court, there were no cases, no legal questions from courts, no actions initiated by subjects entitled to file complaints in the Constitutional Court. So there was no room for assessment of legislation. So the dialogue, or even if it was sometimes only a monologue from the commissioner's perspective with the parliament and with the government, our gradual and regular assessment of the compliance of the restrictions with the constitutional and international standards, they were at least partially, they were taken into account. But how it will go further, we shall see. We ended at least this part with the quite extensive report on the quality of legislation in the times of pandemic. And we will see how it will be used. So we are now in the point of time when there is a peak of pandemic currently, and we'll see the government speaks about the possible return of some of the restrictions. So we'll be monitoring whether those recommendations will be now seriously taken into account.
So without knowing too much about Polish procedural law, if you or any concerned citizens wished to challenge the legislation creating those restrictions and the fines associated with breaching them or the penalties, which court would they be reviewed in? Would it be the Constitutional Court? And then if you are not willing to take actions to the Constitutional Court, would the causes of action be different and taken in different courts?
Mm-hmm. Okay, so when it comes to parliamentary legislation or the regulations issued by the minister or the Council of Ministers, it is for the Constitutional Court to decide. However, there is a long way for those. Some entities like the group of deputies, the Chamber of Control, the Commissioner can initiate abstract proceedings before the Constitutional Court. It is also for the courts, administrative courts and common courts to lodge so-called legal question to the Constitutional Court. And it is also possible for the citizens, but only after all possible legal measures are used. So it is quite similar with the complaint to ECHR, but of course with the differences between the national and international system. But in practice, I may say that the sanctions for infringing the government's restrictions were twofold. One is the fines given by police, and the other method is the sanitary inspection could give a fine. Let me very briefly refer to both. In Poland, when you are sanctioned by police, you may either accept it and then pay, which is at the level of those restrictions, it is limited by 500 zloty, so 120 euros. So you pay, but you may reject this fine, and then the case is transmitted by police to the penal court, and it will be the court will decide on those cases. Because of the I would say pandemics, most of court proceeding has been suspended, so we expect the wave of judgments now. If I read newspapers and statistics that 80 or even more % of fines were rejected by citizens, there will be a flood of such cases in penal courts, and they will decide whether those restrictions were legal or not. And the fines, whether they've been legal. I hope that the courts will take into account the opinions of the commissioners, which are publicly available. We cannot participate in penal proceedings before the courts, unfortunately. Or this is actually the reality. But as regards sanitary inspection, they could give when, for instance, you breached the prohibition of movement, the administrative fine up to 30,000 zlotys, which is really a high amount, which was, I would say, introduced with the beginning of the pandemic. And this is automatically enforced. You have 7 days to pay. You may lodge a complaint to the administrative court, but it is only for the administrative court to suspend the payments. And there are many cases where those fines were given, in our opinion, illegally, with the breach of the basic obligations of the administrations, like the assessment of the personal financial situation of a person fined. So actually, we are, the commissioner is initiating or supporting citizens in all those proceedings. It is actually the task of my department, and we are now in more than 20 cases. First 2 were already finished by the sanitary inspection. The inspector agreed with the commissioner that it was premature to fine with 10,000 zlotys the citizens, and they agreed that there was a breach of administrative code of procedure. So people have legal measures, they can defend their interests, their rights. The commissioner is helping them. However, it will take some time. I think it will take months or even more. to end up all those difficult issues.
Wow, wow. That is unfortunately like all we have time for today. But I could keep talking about this for the rest of the day. But I know that you are incredibly busy. So I just want to say thank you so much for today, for this taking part in this video blog and giving up your valuable time. Dr. Miroslaw Wroblewski at the Office of the Commissioner, the Polish Commissioner for Human Rights. Thank you very, very much. Have a great day.
Thank you very much, Rory, for the invitation, and you are all most welcome to also to see more details and more information on the websites of the Commissioner and also on the website of ENVI, where there is a special web page concerning the COVID situation as regards human rights, and also Fundamental Rights Agency is issuing regularly information on the effects, how the pandemic affects the fundamental rights. So
fantastic. I'll add those websites.
Thank you very much.